Hello, hello. This is Patty Joe. How are you? We are still on day 3. I don't know if this is going to be a hearing or, one of those let's teach Darrell how to try to follow the rules and watch him not follow them. But let's just continue on from where we were.
We'll give you, do you have new forms, Madam Clerk? So we can, do you have extras?
Sitting right here.
What was that?
Oh, wow, that's pretty horrible. Let's skip ahead. There we go.
By the district attorney about there being no factual basis nor no domestic violence incident on November 20th, which they testified to. I think that that's perjury. So that should be.
Well, you're giving me.
Okay, so I skipped ahead a little bit. I think where he is going here is he wants to recall Erica, of course, because he just wants to torture her. And one of the detectives, and then he is calling to keep somebody on the list. My impression of what Darrell did for his witness list is he took everybody who could possibly have been a witness for the state. And then after the state had gone through and interviewed everyone and decided how they were going to present their case and narrowed down their list, there were a group of people that they decided either weren't necessary, it was redundant information, perhaps they didn't have the vantage point, or they ran away faster, or whatever the case was. They weren't a good witness for whatever reason. And those people were who Darrell called, plus Erica a whole bunch of times because, he had to torture her. He's such an icky little man. I think that's
An
going to be
argument, I guess, on
icky
the
little man.
relevance of their testimony, sir, but as I recall the testimony, you were the one asking the questions about the 20th. The state dismissed that charge. I granted that request to dismiss it. There's nothing.
Okay, so then the other piece of this is domestic violence is such a complicated little problem. Okay, so I think we've seen in this case, and I don't know what your background is with DV, but just because there are no legally actionable incidents, and what I mean by legally actionable, now I'm not a lawyer, so that's not the place I'm coming from. I'm coming from when people have made complaints that I've testified to in court as a paramedic, and when I have had to make a complaint personally, and there was and they were deciding whether or not to move forward with the charges. Legally actionable is, can they prove that you were assaulted or whatever with a certain level of assurity for the defendant? Okay, because remember, the state has a very large burden to overcome. So just by saying I said ouch doesn't always get the job done. It either has to be witnessed, or there has to be an injury that can be medically validated, or pictures from whatever attorney or whoever, whatever occurred. It's just not, if it's just not, if you get into an argument, you automatically can claim this and it just goes through and everybody's happy. That's not how it actually works. So a long term, and I'll call it a relationship of this type, where abuse happens in all sorts of ways: financial, mental, verbal, physical, whatever, any number of different ways they can push that person's ego down. The abuser tends to forget or dumb down, or just because it's not proven in a court of law, it didn't happen, which this is what this smells like to me. Just a big pile of dookie that, you know, he's going to get away with it, when basically there were no physical injuries that could be documented. And because then the next day did have a physical injury that was documented, and he committed all of those array of other crimes, it seemed like what he did the day before probably wasn't actionable. And that's really what it comes down to. Anybody else, you know, comment if you see it a different way, but that's what I see.
You are bringing to my attention that
Bringing to her attention that he's an icky little man.
that I can tell would be perjury, but I don't know if what you're trying to tell me is you'd like to question them about their credibility because that charge. Explain to me a little bit further.
It would be a lot to do with credibility, and also a few questions that I believe would still be relevant to even the events of the 21st.
What?
There's
What?
still some relevant things that I feel should be answered, that I feel that the jury deserves to know.
Well, I'm going to give him some leeway. He's a pro se defendant. He has a right to call witnesses. These are two witnesses that testified. He did have the opportunity to cross-examine them, but I think it's reasonable for him to want to question them further, and I'll keep them on your witness list and instruct the state to assist as they have already offered. What about this Kathleen Urell? I know she's on their.
This is one of the witnesses that was probably in the discovery, you know, the full witness list for the state. But this lady, the reason I believe that the state didn't call her is, number one, she didn't see her own children get hit. So she wasn't a hugely strong witness in that way, because she was blocks and blocks away. Her testimony would have been to the aftermath of that, which was, in my view, which is totally a layperson's view, not necessary, because there was video of what he did. There were other people who were able to testify, the family members, the people who saw him with that one lady on the hood of the car, brake so she'd fall off and then run over her. All of these things really made her testimony not quite as needed. You just didn't need to, because there was so much emotion there. So the state dropped her as a witness. She's not, not needed, not necessary. The only good thing that Darrell could bring to the party on this one is that she didn't see him hit anybody. I don't know, we're gonna have to wait for her. But he brought her on the stand, and then what happens to her afterwards is just sickening. And Darrell comes as close to realizing that he is garbage as he ever does. I mean, he gets over it real quick and forgets about it. And it's like a fart in the wind. But what the state, and quite frankly, I think it's the male attorney who does it, has to do to bring out her real story is heart-wrenching. Even somebody as hard as can be in a fire department or, military, or seen terrible things, would listen to this, and it just thinking about it. But let's listen to Icky Dumb Darrell's
Potential witness
rationale
that was filed.
And
I apologize for interrupting, but I did misspeak. She was at the parade, but she did not see, she cannot testify to anyone being struck or injured by the SUV other than her own children that she learned after the fact. And she cannot identify the driver.
All right, Mr. Brooks?
It's still relevancy there. She was at the parade, and as we just heard right now for the record, that she would be directly affected by it, by her family being victims in the matter. Also, she gave statements and she filed a report. I feel like her testimony would be relevant to the matter.
All right, I'll keep her on the list as well.
Thank God we don't have to hear
Anyone
it
else
today.
on
I don't think
the list of subpoenas?
those are going to be his witnesses that are coming later, and he's acting as if it's totally normal for the state to help him serve these things and get these people and arrange this. It's not. And then he acts entitled later. But thank goodness we don't have to hear her testimony today. I don't think. At least I hope not.
No, Your Honor, we'll just await to receive the corrected subpoenas and then we will endeavor to have them served.
All right, thank you.
Just
Thank you.
one thing real quick, Your Honor.
Go ahead.
And if I'm misspeaking right here, feel free to correct me.
If you could correct me.
You said something to the effect about getting more paperwork in during the lunch hour. What was that referring to?
I
Was that referring to
believe
the
it was
subpoenas?
referring to a witness list. If you had one, but what you're indicating is you'd like the grouping of subpoenas and the witnesses who are identified to be reflective of your witness list without filing an independent witness list.
Well, I missed this subpoena. It's only one, but I would have to change it because it was filled out in the same way as the other one. My mistake for missing it. I got a lot of paper.
Who
What's
cares?
On it.
Who cares?
The bias. I don't know. It's spelled.
All right,
I don't want to butcher it.
that's okay. Hand it to the bailiff, and then I'll take a look at it.
It's filled out in the correct. The incorrect, just like the other one. So I would have to essentially change it. But I just wanted that for the record that was lurking in my paperwork.
That's okay. Thank you for providing that. The last name is Babiaszz.
Bobby ass.
Thank you, Your Honor.
Another one who the state probably had on their list and decided not to call. So he thought it was some big conspiracy. Ugh, what an icky little man.
All right, we'll add that to the list. State still have the originals that I handed over to you.
I do.
All right, why don't we give all of those back to Mr. Brooks so that he has those, including the one in my hand. We'll make sure he gets new forms. And then if you could just make sure you
Fill it out right.
provide those at the end of the day today, or by the end of the day.
Well, I don't know if I'll be able to fill all those out on a break.
If need be, I'll let you sit here at the end of the day until you get them filled out, so to make sure the state gets them right away. Okay?
I can try to knock out as many as I can during the breaks to make it easier.
We'll
But
give
I'm
you
not
time.
I'm not sure that
We'll give you time. Don't worry about it. All right, anything else from the state?
No, thank you.
Mr. Brooks, anything else from you?
Yes. At this point, I'm probably beating the dead horse, but I just have to stay for the record anyway.
Yes. You're beating a dead horse. You're going to continue to beat this horse until it is the dust has rolled out from a slight breeze. But let's go, icky little man. Rock on.
I would like to direct your honor to, I believe it's Milo versus United States, 505 F2D 1026. Are you familiar with that, your honor?
Not off the top of my head, but I can pull it up.
And also Higgins versus Levine, 415 US 533. And those cases are being brought up because of the continuing asking of me about the
Asking of me
that I've been
jurisdiction.
challenging.
The jurisdiction.
I believe they're very, very relevant to this matter.
Clearly relevant.
Could I ask Mr. Brooks to repeat those numbers again?
For both,
Yes, please.
for Milo, I believe it is, or it might be Milo, but Milo. Versus
M-I-L-O?
Milo.
Is it M-I-L-O, the spelling?
MELO.
Oh, I had it right the first time. Okay.
505 F2D 1026. And Higgins versus Levine, 415 US 533.
Anything specific you want to draw my attention to?
Well, there's cases that challenge the jurisdiction, which I've been doing, challenging the jurisdiction. Milo versus United States states once jurisdiction is challenged, the court cannot proceed when it is clearly appears that the court lacks jurisdiction. The court has no authority to reach merits, but rather should dismiss the action.
I think I hear that being federal, and I don't think that falls under this court. But I'm going to wait till that, because I don't even think it's even worth looking up. I think the prosecution probably going to bat these right out of the park. Let's see what he says about the other stupid one.
For the record, Mr. Brooks, the Higgins versus Levine is 415 US 528. Perhaps
Whoa.
you're drawing my attention to page 533, but the site for the case is 415 US 528.
That could be so. I apologize if I'm stating it wrong.
What about the other
I
case?
believe it's, well, the information I have is 533. That states the law requires proof of jurisdiction to appear on the record of the administrative agency in all administrative proceedings. We have yet to prove the jurisdiction. It has yet to be proven. I've filed a motion. I've stated on the record numerous times. I have yet to get an answer.
You actually got an
You're
answer.
specifically referring to the documents you filed on October 3rd.
I've been challenging jurisdiction since the beginning of trial, probably as far back as when I became a pro per defendant myself.
Proper.
Also, you can look at U.S. versus Lopez. You can look at, I think that's from, it may be from 1995.
Do you have a citation?
Just really quick. I may have to find it in my paperwork for the Lopez.
All right, well, you locate that. When you find it, let me know outside the presence of the jury. I'll take your request under advisement. I'll take a look at these cases. I don't believe they're going to change my previous ruling that the issues that you have raised are without merit. As previously ruled on, but I'll take a look, and if I feel I need to address it further, I'll give you an opportunity to argue.
I believe it should be addressed. Thank you, Your Honor.
All right. Then with that, we are still going to continue, Mr. Brooks, and we'll bring the jury out. I presume the state has the next witness available.
Yes.
All right, Madam Clerk.
I'm going to pause it right here for a minute. I have to attend to something really quick, and I'll just post this real quick, and then we'll start with the next witness with this icky little man.